Welcome to the podcast for Library Security, sponsored by Library 2.0. I'm Dr. Steve Albrecht. Great to be with you as we talk about a complex and difficult subject for library employees as they deal with library patrons, which is the issue of sexual or racial harassment. And these are things that are coming from the patrons towards the staff, and it's a concern that I've seen as I've traveled around the country. So let's talk about some of the issues related to this complex and disturbing concern that we have for the safety of library staff and the ability for library supervisors, managers, and directors to set some boundaries about this concept. The scope of the issue for sexual or racial harassment in the workplace is it is an unwanted behavior that comes to the attention of library staff, typically from a patron who violates some boundaries in terms of flirting and things like that, which sometimes goes out of control when they get beyond where normal conversation steps into an area which is kind of creepy. If we look at library patrons in terms of their behavior, we always look at what the impact is on the business and how does this hurt the business in terms of what library staff want to tolerate. Sometimes library staff members can simply say, don't talk that way to me, don't ask me personal questions, I won't be answering personal questions, and they can get past the issue, and that solves the problem in the first time. However, sometimes, as we have seen, and I've heard lots of stories from around the country, library patrons will sometimes push the envelope in terms of asking personal questions or making sexually or racially harassing comments that they think are okay or appropriate, when in reality we know that they're not, and this needs to stop. If we look at the concept of kind of the scope of sexual harassment, the thing we're most common that we see typically in organizations is the idea of a quid pro quo sexual harassment situation, which is Latin for this for that, which is give me sexual favors as a condition of employment, as a condition to keep your job, as a condition to be hired. This is illegal behavior. Sexual and racial harassment was made illegal in 1964 by the passage of the Civil Rights Act, 1964 Civil Rights Act signed by President Johnson. Of course, policies and legislation don't stop actual behaviors, but it certainly gives us consequences to enforce, and we know that these illegal behaviors are what gets organizations into problems if they don't step up and protect their employees from these types of things. So the quid pro quo, sex for condition of employment, is the thing that most people think about when the concept of sexual harassment comes to mind, kind of in the Hollywood casting couch kind of old days sort of perspective. Certainly the Me Too movement has identified some perpetrators in this situation. The good news about that concept is it's about 5% of the problems in the United States. Per the Equal Employment Opportunity Commission, it's about 5% of the cases that we typically see. I have not seen evidence of this situation, quid pro quo sexual harassment, in libraries specifically. Most of the things that I have seen are related to patron behavior, which I would say almost 100% of the problem. We can also look at sexual harassment between library staff members. This is things that happen where a library staff member of a sexual or racial nature would harass another colleague or coworker. Again, I have not seen those types of situations, although I know they happen, but in the libraries it's pretty rare. If we go back to the issue that we look at demographics in library employees, if you consider the American Library Association statistics that the number of female employees working in libraries in the United States is somewhere between 70 and 80%, male employees 20 to 30%. I just don't see the type of sexual harassment involving staff members that I would see in the private sector or in some of my government agency situations. Doesn't mean it doesn't happen, but that's not the thing I'm most exposed to when people talk to me about this issue that they are concerned about. What I typically see is the patron who has boundary issues, and this person continues to bother and pester and harass library employees, starting off what they think is harmless behavior and really escalating their behavior into an area where the supervisors need to get involved. We'll talk about some of the remedies for sexual harassment in the library environment in just a moment here, but I really want to look at kind of an opportunity for library staff members to step up and save themselves from a lot of grief about this issue by having the courage, with a capital C, to report. Sometimes I hear from library employees that they're afraid to report this type of situation because they're embarrassed about it. They're afraid to report because they think that somehow they are the victims and they have caused the problem, which is not actually true. The perpetrator is the one that caused the problem. And also that they're afraid to speak to their employers, their supervisors about it, because sometimes they're not sure what the employer's reaction is going to be. The worst part of that situation is when employers, bosses, managers, supervisors, library directors say things like, he's harmless, or it's no big deal, or it comes with the territory, or I've heard things like, you should be flattered with the attention, or he's not that big of a problem, and in fact that he does it lots of other places. What are we supposed to do? We can't control human behavior. I mean, these are some of the answers that I've heard from library directors, obviously all of which are wrong. The response by library supervisors, managers, directors should be, when an employee comes to their office, really, come, let's sit down, let's talk about what happened here, let me close the door, let's have a private conversation about this specific situation, and let's figure out what we need to do about it. One thing for library supervisors and managers and directors to realize is that not every situation involving a type of harassing behavior from a patron may not be of a sexual or racial nature. It could be just a general jerk, just somebody who does not have good social boundaries. It is not of a sexual or racial nature. We still need to address it, but it's a kind of a different category than sexual or racial harassment. When we know it, when we see it, we know it when we hear about it, we see evidence of it, whether it's things that the staff member has been touched by this person, or this person continues to text or email our staff members in an attempt to start a sexual relationship. Again, these are unwanted behaviors that we need to address as library supervisors, managers, and directors. So there's a concern that I have that employees are afraid to report, and they're afraid because they think that nothing will be done or that the problem is not big enough. Even small level, low level sexual or racial harassment situations need to be addressed immediately, and that typically involves confronting the patrons, telling this person to stop the behavior. If we look at the first line of defense in these types of situations, it's typically the employee to say to this person, don't talk to me that way. Don't have these questions to me. I will not answer them. I will not answer personal questions. I'm glad to do my job on your behalf in terms of helping you with what you need from the library, but I will not tolerate that type of behavior coming to me. And sometimes just putting that person on notice immediately, once these things come to your attention, solves the problem. It's for those specific situations that this person's behavior does not stop, or the employee is intimidated or fearful about confronting this person, that supervisors need to get involved. Now, the issue that we face sometimes with the supervisor's involvement is it comes after this thing has been going on for several months. And I want employees to have the courage, with a capital C, to say, I have a right to work in a safe place, and I need to tell my boss or my boss is what is going on so that we can address this. They can address it specifically to the patron, so I don't have to get involved confronting this person if I don't want to. And they're going to make the behavior stop, up to and including kicking out the person or setting up something even like a restraining order, as I have seen in certain situations. When we look at the wrong responses by bosses, it sends a message to employees that the issue is not important, or that their concerns are not important, and it's not what we want to happen. We want supervisors to address these things as soon as it comes to their attention. But as I say to employees all the time in our training programs, you cannot address what you don't know. So supervisors have to know what's going on, and they can't guess about these situations. Sometimes, too, what we have seen is I've seen this as a successful solution to the problem is where several employees will come to bosses together and as a staff have a conversation and say, here's what this particular patron or this group of patrons, typically males, are saying to us, and we want it to stop. And that's the first time it comes to their attention that they address it, and it goes to supervisors who can step in and do something about it. So talking with your colleagues as a library employee about this person's behavior may be useful from a beginning part, but it's not useful to get the problem solved until a supervisor can step in and enforce consequences. Let's talk a little bit about what consequences look like for these perpetrators of sexual or racial harassment, up to including being kicked out or banned from the library. But also we can do things like, guess what, sir? You get to do business with this supervisor over here. Guess what, sir? We're not allowing you to engage with our employee here based on your previous behaviors. So you can still use the library, but you won't be engaging with this employee here based on what you have said or done to him or her. Now, I realize sexual harassment happens in same-sex sexual orientation, happens for transgender employees. I'm cognizant of the fact that it's a pretty broad brush that we're talking about in terms of who could be a victim. But for the most part, the cases that I have seen are male perpetrators and female victims. That's the largest percentage and typically what I'm going to be talking about, even though I do recognize it happens across the board. If we get past the quid pro quo and we get past the library employees sexually or racially harassing each other, which is quite rare and I've typically not seen, it's really about the boundaries that these patrons have, boundary problems, and not being having good social intelligence and not being able to manage their behavior around other employees is the thing that we want to address. I frequently tell employees in the library that it's kind of ironic that we're in an information providing business, and sometimes these perpetrators use your internet, your Google searches to find out information about you personally. I'm not a huge fan of name tags with the employee's full name on it. I like your first name and your title. Sometimes we see a lot of information that you can get off a first and a last name in Google. You say to yourself as a library employee, well, my personal information is pretty well hidden and I don't have a big social media following, or I'm not on social media that much. And then you find out that you signed up on some checklist somewhere in some store, or you put your name on an address on a list at church, and that gets scanned and put on the internet, and that's how this person figures out where you live. So I have seen situations of sexual racial harassment escalate to the point where the patron is confronting or following or stopping the employee in the parking lot before he or she comes to work or after they leave for work. I've seen situations evolve into stalking as well. Stalking is a crime in all 50 states. It is a set of behaviors done by the perpetrator designed to make the person that's on the receiving end feel afraid for their safety. Stalking is not just an irritating thing, it's a fear-creating thing. It's not just something where you say, I wish this person would go away. What you're saying is, I'm fearful this person's going to harm me. And that's a big difference than other types of harassment that we have seen. If, and I say this to library employees all the time, you have any interactions with patrons outside of work that make you feel fearful that somehow they've come by your house or stopped you at the gym or seen you at the grocery store, you must tell your supervisor immediately, including the library director, and it's probably a situation that's going to involve the police. The police function in these situations is to investigate these things, figure out whether this person has a criminal background or the kind of background where you may be in jeopardy of being harmed, and what we need to do about it in terms of intervention to get this person from bothering you to the point where you're fearful of going to work or leaving your car in the parking lot or coming in or going out of your facility. That's when stalking is a serious issue. Many times people ask me about the violence piece of stalking, and for the most part, what I have seen in my career is that stalking is most likely to turn to violence anytime there was previous sexual intimacy between the victim and the suspect. If there was not previous sexual intimacy between the victim and the suspect, the I can't have you, nobody else can kind of a guy, violence is much less likely, in fact quite rare in those types of stalking situations. Most of those perpetrators are typically irritating, creepy, immature people that can't control their space and boundaries around other folks, and they develop sort of a target list where they come after people that they become infatuated with. When it comes to revealing personal information, I think you have to be firm and assertive and even sometimes not very polite when telling somebody, I'm not going to tell you whether I'm married, I'm not going to tell you whether I'm dating, I'm not going to tell you anything about my personal life, I'm not going to tell you whether I have any kids or what neighborhood I live in, I'm just not going to do it. I'll be happy to do my job on your behalf and to help you with the information that you need when you come to the library or the services that you need, but I'm not giving you personal information about my life. And I think sometimes our parents told us to be kind to people, and sometimes I think you have to be rude sometimes when it comes to your personal information that somebody keeps chipping away at in an attempt to find things about you that they should not have to know. When we look at sexual harassment, racial harassment from an overall agency standpoint, there's a couple of factors here which really have to apply. One is that we have a written policy. And I have not seen organizations never have a policy. I have seen some that the policy is not up to date and it's not very well written, and I've seen some where the policy goes on for page after page after page and it's too long. I think there's sort of a just right kind of a feel for sexual racial harassment policies. One page is too short, 19 is probably too long, but there's kind of a sweet spot in terms of the things that we want to cover in the policy, which is, one, very important, how we have employees to report these issues. And we talk about something called multiple channels of reporting. Multiple channels of reporting says if you are sexually or racially harassed, you can speak to your boss or your boss's boss or the library director. You can go to the human resources function in your agency if you have one. You can go to an elected official in your city or county. You can go to the elected attorney or district attorney, county council, town lawyer for your particular agency, and you can make a report that way. We tell people in responsible charge positions, elected officials, appointed officials, people that work in supervisory positions, that they are responsible for hearing sexual harassment, racial harassment reports when they come to their attention. The reason for this is obvious. When we say to somebody, the only person you can report sexual or racial harassment to is your boss, and your boss is the one doing the harassment, then people don't report. So we create the concept of multiple channels of reporting to say it's up to you to go to any number of these resources, and if you feel more comfortable speaking to somebody who's not your direct boss, that's fine. Speak to that person. And the information from my perspective is I want you to report regardless of the fact that you say, well, I have to go through the chain of command. You don't have to go through the chain of command. You can talk to anybody inside your organization who is in a responsible supervisory position and a leadership position to get some help for your concerns. The second thing that the policy has to talk about is the investigative process. How do we determine it was a policy violation, that your rights as an employee in terms of not being sexually or racially harassed have been violated by this patron? And from that perspective, we do have to do an investigation. And the investigation itself can be typically the library director or manager or supervisor speaking to other supervisors about what they have seen perhaps, and from the same patron when it comes to their employees, or talking to the library director about anything that's been gathered about this person in terms of their past behavior. We can look at files and security incident reports to look at a collection of behaviors over a span of time. We can also confront the patron as part of the role of the supervisor to say, it's come to my attention that you've sexually or racially harassed our employees, one or more, with this type of language or behavior, where we use specific examples, and we confront the person. And we put them on notice at that point, and we put them on a warning at that point not to continue the behavior. For low-level sexual racial harassment situations where there's no physical contact, there's no harassing behavior that follows outside the library, for things that can be addressed through a verbal warning specifically with a patron, that's usually solves the problem. We may need to get to written warnings and banning the person for some span of time and changing the way that they do business with the library. Those are all possibilities as well. But typically what works best is confronting the behavior as soon as it comes to the attention of the supervisor. So we go back to what we have talked about, which is it's not necessary for you as an employee to confront the person who's doing these things and tell them to stop, but it is the first best line of defense. When we look at sexual and racial harassment as a concept, the first line of defense is not your boss. The first line of defense is not the agency policy. The first line of defense is you telling this person to stop the behavior. They may not understand based on cultural or language issues that their behavior was inappropriate. They may not understand because of immaturity or other concerns that their behavior is inappropriate, but once you put them on notice, then they have to understand that these behaviors have to stop, or there are more consequences for what's going to happen, up to and including they're kicked out of the library. So we have in the policy the concept of multiple channels of reporting, the investigative process, and again, that could take some span of time from several days to several weeks to figure out what actually went on. There may be a review of documentation or evidence, things that you have provided in terms of text or things that were emailed to you or sent to you or voice messages or things like that that prove what went on. Those things need to be evaluated. The third thing is that we come to a conclusion and we have consequences for the perpetrator and support for the victim. We don't allow retaliation. We don't allow for multiple opportunities for this to happen again. We don't retaliate against the employee who made the investigative claim in the first place because that's illegal behavior. We support our employees when they bring these things to our attention. And then really the last part in the policy is that we continue to monitor. We monitor for repeated behaviors. We make sure that retaliation doesn't exist. And that's really what the policy does. So the concept of multiple channels of reporting is really sort of what kicks us off. The investigative response gets a set of conclusions as to whether or not what happened took place. There is an intervention step where we talk as the supervisors, we talk to the patron who has done these, and we create consequences for this person. And again, we can change the way this person does business with the library. We can set it up so they can only do business over the internet or by email or only by working with a supervisor or working with another employee. Think about the possibility that you're an employee in a library chain that has many facilities. Your library agency has many branch locations, and the supervisors say, well, we'll just move you to another branch, or we'll just move you to the back office that you don't have patron contact. That could be perceived as retaliatory. You brought this problem to their attention and they ship you off to another branch. Now, the dividing factor for that is when you say, Okay, yes, I would like to go to another branch. I am concerned about this person's interaction, and we've seen escalation of their behavior, and I'm a little bit fearful. I would like to go to another branch. And in stalking situations, we have done that, especially when there is a domestic violence concern. There was previous sexual intimacy between the victim and the suspect. We have moved employees to new locations. There again, it's something we agree upon. It's not a retaliatory step. It's an agreed upon step to say, let's get you out of harm's way, and while we lower the emotional temperature and figure out what's going on here and try to enforce consequences, that we set it up so that you can work safely in another place. But simply moving you to a new branch or putting you in a back office location that in your same branch could be perceived as retaliatory and may not solve the problem. So when we look at ways to enforce consequences, again, it could be something where it's pretty extreme, like a restraining order, or it could be simply start out with a verbal warning against the patron to stop these behaviors. The verbal warning also needs to be documented in any kind of collection of notes or files that we have about this situation, and say, in February this came to our attention and we addressed it immediately with the patron. We've not seen a continued behavior here, or we have seen continued behavior starting up again in March, April, or May, in which case we reinforce more strict consequences, and we try to set deeper boundaries for this person. When you look at kind of the issue from the standpoint of the courage it takes, it's really a multiple thing. You need the courage to report as an employee, and you can start off with the courage to have this person stop the behavior by putting them on notice. Don't touch me, don't say these things, don't say sexual or racial things around me, not even in a joking way. I'm not interested in this. You will have a service relationship with me that doesn't include these things, or I will not be able to help you. And then the second part is it's something that your coworkers need to have the courage to support you and to talk about their own issues as well. Many times in organizations where we see a patron do this for one employee, they've done it for several employees. And when it comes to things like really serious sexual harassment or racial harassment and stalking, they tend to have multiple victims. They have multiple people that they aim these types of inappropriate behaviors at, and we need to know about this. So it's not just that we can talk as employees in kind of a break room conversation back and forth type of thing, but we need to have a staff meeting with our supervisors and our leadership team to say, we as a group have concerns about this patron's behavior, we have concerns about this patron's interactions with a lot of us, and it needs to stop. And I think what happens sometimes is supervisors don't always hear the full story, or don't always see the impact of the issue, and don't realize how serious, or in some cases how systemic it is around the organization, and they need to know about this and they need to address it. Let's talk about the most serious consequence for a patron, which would be a civil restraining order, typically a TRO or a temporary restraining order. In order for those things to work, which is to ban this person permanently from the library for a 1-year span of time, or up to even including 3-year span of time for a permanent restraining order, we have to have a pattern of this person's behavior with evidence over a span of time. And typically what judges are looking for in these situations, and these cases are argued by your district attorneys, your city attorneys, your county councils, your town attorney, your county council, whoever it happens to be, is here, Your Honor, is a collection of this patron's behavior, including copies of images of text or emails or things this person has tried to expose our staff member to, which proves the point that this behavior is not being addressed by typical verbal warnings, and in fact their behavior has escalated, and we want to the point where we want to kick this person out. We do not want to provide services to this person. In order for that to happen, we've got to have a collection of their behaviors over a span of time, which will point to a pattern of behavior. A reasonable person, hopefully like a judge, will say, okay, I see what needs to happen here. This person cannot be allowed into the facility anymore. It's not just a one-time thing, it's an over and over type thing. So what I have seen oftentimes in libraries is we will have sort of an oral history of this person's behavior, and you say, how long has this guy been doing these things? And we hear 2 years. And then I say, well, when was ground zero? When was sort of the first application of this problem came to our attention against one of our staff members? And the managers and supervisors will say, well, we think it was about 18 months ago, and they don't have a very specific time. What I'd like to see in my perfect world is that we have a collection of security incident reports that go back over this person's behavior and say, here we are over a 1-year span of time, or 2 months, or 6 months, or however long it happens to be, that we can take to our attorneys and say, here is proof that these behaviors have been going on. It's not an accidental thing on this person's part. It's an intentional set of behaviors, and we need to address it with a restraining order. Typically, the restraining order process happens when This person is served with a subpoena, basically, that says you're going to go to a court appearance and you're going to defend yourself, or you're going to try to defend yourself in front of a judge. The town attorney will make their claim as to why we need a restraining order to protect our library staff and protect our facilities and protect other patrons and protect other employees from this person's continued behavior. And with that in place, the person can make their argument to the judge as to why they shouldn't have this restraining order, and the judge, oftentimes looking at the collection of evidence, will decide in our favor. Now, sometimes these people don't show up at the restraining order, in which case the judge will say, okay, by default, we will win the case, and he'll issue or she will issue the restraining order, which typically has a 1 year to 3 year time span, depending on which one we have for our particular counties. So the restraining order is sort of a nuclear kind of solution to this issue, and no question about it, but it sometimes is necessary based on this person's overall behavior over a long span of time. So talk to your coworkers, have the courage to share information with your bosses, realize this multiple channels of reporting situation exists for your benefit so that you can speak to people that you feel that you have the best trust with. And that's something I say to supervisors all the time. Just because you don't typically supervise this person as in your direct chain of command doesn't mean they don't trust you and like you and want to talk to you about something. Maybe you have history going back with them. That's why they want to come and speak to you, not necessarily talk to their boss. So we don't punish employees for coming to other supervisors to get help in these situations. We, in fact, encourage it. And that's what the concept of multiple channels of reporting is all about. When we look at what has to happen in terms of the investigative process, you need some patience while supervisors and maybe the HR team figures out what to do. I've had lots of examples where they will bring in an outside investigator or an outside attorney, and sometimes these people will interview a lot of people, including the perpetrator, to try to figure out what went on and come up with some sort of conclusion, which ends up in a notebook, which can be several inches thick. So we look at the cause and effect of these situations. Sometimes we find out multiple victims with one perpetrator, which we want to address everybody's concerns, give them a chance to tell their story. Sometimes we will bring in a private investigator for this. We'll bring in an outside counsel. The attorney in your particular locale will hire outside counsel who are experts in these types of investigations and to look into what happened. So these are serious allegations that we want to make sure that you're protected from as an employee for your rights. These are serious allegations. When we go to the serious step of banning a patron from coming into the library, we want to make sure we've done the right things. So this is a complex subject. It's one that I hear about when people come to me and say, can I tell you about this guy that comes in and I'm afraid to interact with him, or I don't know what to do. And I feel like it's an issue that we need to address collectively. It's not a you concern, it's an us concern. What do we do as a library system? And I'm hopeful that the things that we have talked about today as potential solutions for you will give you the courage to come forward, talk to your coworkers, talk to your bosses about the things that you've been exposed to. Certain people have a different sort of tolerance for things, but I think we all agree that there are certain behaviors, things that happen from a verbal basis or a physical basis that you should not have to tolerate as an employee. If we look at sexual and racial harassment as having a verbal component to it, what these perpetrators say, as opposed to a visual component, which is things that they show you or they send to you or email or text to you, and then the third one is physical contact. I'm a huge believer that nobody should touch anybody in the library against their will, and I have real strong concerns about patrons who touch employees in a physical way, especially in a sexual way. That needs consequences, up to and including calling the police. And that's really my first sort of crossroads as to banning people, is when they touch our staff members in a sexual way, and that's what they should get arrested for, or at least kicked out of the library. Those are behaviors we should not tolerate in any way, shape, or form. But a lot of the things that I deal with are low-level things that are allowed to escalate and kind of get out of control. We look at situations that could have been handled more skillfully by a supervisor earlier on, and sometimes that's the fault of the supervisor, and sometimes that's the fault of the employee for not talking about these things in a timely way or early enough. But working together, bosses and employees, co-workers together in staff meetings and conversations, we should be able to come up with solutions for this type of issue so you work in an environment that's safe and peaceful and you're not exposed to this type of behavior. It's a condition of employment for you to say, I have the right to work in a safe place that's harassment-free. Part of my obligation as an employee is to tell my bosses when this isn't happening, and part of the obligation as a supervisor, manager, director is to address it and confront these behaviors in the patron when it does come to our attention. So thanks for your time and listening to the Library 2.0 Security Podcast. I'm Dr. Steve Albrecht. The Library Security 2.0 podcast is sponsored by Library 2.0 and executive producer Steve Harganen. I'll see you next time when we talk about another subject related to library security.